It is an historic first and a landmark decision that could have huge implications right across Canada. It came from the Supreme Court of Canada, a unanimous decision today handing victory to a British Columbia Aboriginal group, ending decades of battle over its right to a piece of land. The case revolved around this 4,000 square kilometre tract west of Williams Lake, BC. The court ruled the group does have title or rights to about 1,700 square kilometres of it, to use, enjoy, and more. But what about those implications? They'll touch government, industry, and any future economic or resource development on First Nations lands, including the newly approved Northern Gateway Pipeline. We have full coverage tonight, beginning with more on the decision itself from Duncan McHugh.
What Roger Williams and the Tsilhqot'in chiefs told the courts their ancestors had been saying since settlers first arrived. Their lands were still theirs. Today, Canada's highest court responded.
I was ecstatic to find out that we had title, and it's about time.
For more than 20 years, the Tsilhqot'in argued forestry officials had no business permitting clear cuts in Tsilhqot'in traditional territory without consulting them, because their rights were tied to a vast swath of BC's interior where they hunted, fished, and lived. No, responded the province, those rights only exist in tiny areas, such as their old village sites. After hearing the claim, the Supreme Court of Canada was unanimous. The Tsilhqot'in hold Aboriginal title to over 1,700 square kilometres, stating the title holders have the rights to the benefits associated with the land, to use it, enjoy it, and profit from its economic development. And where title is found, governments and others seeking to use the land must obtain the consent of the Aboriginal title holders. It's the first time the High Court has recognized Aboriginal title to a piece of land. Yet the justices made clear it still falls to the province to regulate land use decisions in BC, and the province can justify development if it's, quote, in the public interest. First Nations declared victory.
This has to be the wake-up call for governments, both the provincial and the federal governments.
With large parts of BC not covered by treaty, the ruling will most certainly impact resource extraction industries, such as oil and gas, mining, or logging.
And we're moving away from the world of mere consultation into a world of consent. And that is absolutely enormous when one considers Enbridge's Northern Gateway Pipeline proposal, the Kinder Morgan Pipeline proposal.
The BC government cautiously welcomed certainty around the rules.
We've seen the benefits that come to First Nations communities, and indeed to all of us, when First Nations have the opportunities to fully participate in the economy.
Before today, Aboriginal title was kind of a theory. It existed somewhere out here, but no one was sure where. Now we know First Nations essentially control pretty hefty chunks of their traditional territory, and Peter, there's no question that this is going to shake up the BC treaty process.
You're right, Duncan, but it doesn't end with BC. There's a lot at stake here for Aboriginal groups right across Canada, right?
Yeah, certainly in parts of Ontario, Quebec, the Maritimes, anywhere where land cession treaties don't exist. And the decision makes pretty clear there's no question that Aboriginal groups are now going to have a stronger hand at the negotiating table.
All right, Duncan, thanks very much. Duncan McHugh in Vancouver tonight.